Good afternoon. Let's begin. Just a couple of announcements for today. I have office hours this evening, beginning at 6, from 6 to 8. What else? I think that's pretty much it. A couple of suggestions that I have based on conversations that I've had with folks individually. Obviously, I encourage you to come to office hours individually. If you are not able to come to office hours, the second thing that I encourage folks to do is that if you belong to a study group, and there are folks that you meet regularly to study, I'm happy to have appointments with your group outside of office hours. Simply send me an email and let me know. Lastly, if as an individual, for whatever reason, you find yourself sort of struggling with the material a little bit and not quite able to sort of match your reading of the cases to the discussion in class, you should feel free to contact me and I will make an individual appointment with you. And chances are over Zoom, and it can be, and I've already done that with some folks, and those meetings can take place at any time, including during the weekend. I'm not suggesting I'm able to meet individually one-on-one with everyone in the room, obviously, considering the size of the class, but the truth of the matter is, not everybody will call me for an individual meeting. So if in fact you think you need that individual attention, you should feel free to reach out. And the reason why it's important is because come, say, the end of next week and the beginning of the following week, we're moving on to an entirely different, though related topic. We're going to move on to the topic of subject matter jurisdiction. And while there is some overlap between subject matter jurisdiction and personal jurisdiction, the truth is, once I leave this topic, I'm not really going to come back to it. I'm simply going to assume you've essentially mastered it, which is the reason why, if there is any ambiguity about the discussion, you should definitely come and talk to me. The last thing I'll say is that another thing you can do if you do not wish to come to office hours or to meetings is that the reason I'm encouraging folks to sort of complete their own version of the chart is that if you do, and the version is available electronically, and you email it to me, I will respond to you. I will tell you whether or not you're on the right track. Now, as I'm sure that most of you already know in this room, there are tons of versions of these charts floating around from prior semesters, some more accurate than others. I still think it is not worthwhile for you to simply go to your friends and say, can I have a version of the chart? Because it is important for you to sort of try to go through it, through that process yourself. Okay? All right. So the plan for class is the following. I'm fairly confident that we can continue and finish the discussion that we began with Asahi and McIntyre. I'm fairly confident also that we can go through and really cover the distinction between specific long-arm jurisdiction and general long-arm jurisdiction and then general jurisdiction. We'll obviously talk about FORD, which is the last part of the minimum contact test. This sort of relate to or arise out of those contacts. And I think I'm fairly confident that we can very quickly but very clearly cover the cases that are assigned that were going to assign this past Tuesday, namely having to do with jurisdiction based on contract or based on consent, which is actually fairly simple. I think I can probably introduce Schaefer, though I'm not entirely sure that will cover it in its entirety. But if you look very carefully at the syllabus, what you'll notice is that the readings for this coming Tuesday are relatively light. There are basically very few cases for this coming Tuesday. It's because I always anticipated the cases for this week will sort of spill over next week. Okay, so then let's step back as always and review very briefly where we are. You know, imagine class is over today and you're walking somewhere. You're walking back to your place or you're going out to have something to eat and a police car pulls over and stops. The officer comes out of the car and asks you, where are you going? Now, some of you who are very deeply familiar with the law might respond, I don't have to tell you, because you actually don't have to tell an officer, they simply ask where you're going. But chances are most of you will instinctively respond that you go into it. Then the officer asks you, can I have your phone? Right? Now, again, some of you might have the presence of mind to say, on what basis are you asking me for my phone? But many of you might actually instinctively hand them your phone. And then the last question the officer might ask you is that, can I have your code to open up your phone? At that point, I think I'm fairly certain that most of you in this room would resist giving the officer your code, right? Because I'm guessing, like, most of us, you have an extraordinary amount of personal and private, if not to say embarrassing information on your phone. And you know that the officer has gone too far. And I think part of the reason that you would resist giving your phone number, your code, is that you realize, well, there is such a thing called due process. And so far, the officer has managed to essentially exercise a tremendous amount of force against you. It is from force, right? And yet, the officer hasn't given you any indication as to what the process is owed to you. Right? The same thing happens whenever you're sued in court. Most of people do not think about it in those terms, but the act of being sued in court is as coercive as being stopped by a police officer. And therefore, all we've been talking about so far is that before you can be forced to do that, there are certain steps that, the court has to engage in, right? If the officer were to stop you and place their hands on you and put you in handcuffs, I think you would immediately understand the concept of state violence. I'm not using the word violence in the political sense, but the idea that a person puts their hands on you and puts you in handcuffs is a form of government violence. Now, that violence by the government can or may be justified, right? In other words, it can be justified because, in fact, you've done something wrong. Or even if you have not done anything wrong, that violence can be justified if, in fact, the state has taken a number of steps to make sure that before it exercises that violence against you, it has done so in a fair and procedural way. Right? Well, there is nothing that is a greater indication of state violence than the court system. Right? An academic, once read an article that sounds hyperbolic, in which the first sentence of the article says that law takes place on the field of violence and death. And while it may sound like an exaggeration, it means that the way that you put into court, right, your life essentially, whether you win or not, is going to be turned upside down, right, in one form or another. So all we've been talking about so far is if the state is going to engage with that form of violence, and it is a form of violence against you, then what procedure must it abide by to make sure that whether or not substantively it has the right to exercise that violence, that at least procedurally it is doing so in a fair way. Right? And the very first question that we've been talking about is, can they exercise personal jurisdiction over you? Right? Now, I know that I've put a lot of things on the board so far, but to sort of go back and review, we began by saying that one of the first questions you can ask is, are you a citizen of the state? And we said that you can either answer the question, it's a yes, or it's a no. Right? If you're a citizen of the state, right, then there is jurisdiction over you if, in fact, you be given proper notice. And by the time we finish this topic next week, you'll be able to expand this particular part of the chart as to what proper notice means, right? And I ended by saying, yes, you've been given proper notice, and then the last thing I said is that there is jurisdiction. But when I said that on Tuesday, as I'm sure some of you may have realized when you're reading the cases, it wasn't precise enough, right? In other words, to be more precise in your chart, by the time you get to this point, what category of jurisdiction can exercise over you as a court if in fact I reach that point of the analysis. Yes? General jurisdiction. So it's not just jurisdiction. It means I'm exercising general jurisdiction over you, meaning you can be sued, right, for anything or everything. Okay. The other thing that you'll notice that you can expand your chart based on the reading of the cases so far, including Ford, which we're going to talk about today, is that this is not expensive enough, right? Because in talking about whether or not you're a citizen, you can be talking about a person, an actual human being, in which case all you need to do to know is that the person is a citizen. Or you can talk about an entity or a corporation, right? Now, what I've mentioned in the past, and the cases make it clear, is that if you're a corporation, right, there are two ways you can be deemed to be a citizen of a place, or presence, if you will. One is the state where you happen to be incorporated. Think of Michigan, think of the Ford case. Ford is incorporated in Delaware, right? But at the same time, Ford's principal place of business, its main headquarters, happens to be in Michigan. So Ford is a citizen of both Delaware and Michigan. So you can take care of that part if you want to. If the answer is no, we kept talking about, well, are you present in the state? Right? Now, one way to answer the question is to say yes here or say no. I can promise you that based on the reading that you've already done, you know exactly how to expand the issue of presence, right? Because by the time we get to transient present next week, you'll be able to talk about Burnham and what presence really means, right? But let's leave that aside for now. We also talked about the fact that if the answer is yes, you are present, right? Then we go back to here, in which you ask notice and yes. And again, based on your reading, you'll be able to expand this part of the chart. If you're present in the state, believe it or not, the jurisdiction that we can exercise over you is also general. Right. Finally, if the answer is no, you're not present in the state, then what we are asking ourselves is whether or not there is minimum contact between you and the state, so that the minimum contact, so that jurisdiction can be exercised over you consistent with fair play. Now, a lot of you have asked me, well, what do all these terms mean? Fair play, minimum contact, personal availment, all of that. This is where we've begun to expand the chart, and you can begin to expand it based on the cases. Now, this simply is a way of measuring fairness. This is a way of measuring fairness. It was done by a territory. This is being done by simple minimum contact. So one way of breaking down the analysis is to essentially says, well, the first thing I know I need to ask for minimum contact is whether or not there's been purposeful availment. The only thing that really means is whether or not the contact that have occurred between the defendant and the foreign state was done through some purposeful action on the part of the defendant. Why is that the initial question to us? Because if in fact those contacts occur through no action by the defendant, then there is no point in going any further. You can go further if you want to. You can sort of, well, since you didn't do it on purpose, it's not forcible. But the fact of the matter is, the lesson to be learned from Worldwide Volkswagen is that if the contact that occurred between the defendant and the state occurred because, unbeknownst to the defendant, through no action of the defendant, some other party or the plaintiff dragged the defendant into contact with the state, then there hasn't been purposeful availment. And if there's no purposeful availment, we can stop right there, right? But we also talked about the fact that, so in other words, if the answer is no, then I guess you can basically stop the jurisdictional analysis. But the answer is yes. That still is not enough, because as we talked about on Tuesday, if the answer is yes, you still have to ask for, is there foreseeability, right? Because we know there are instances in which you can purposefully engage in contact with the state, right? And yet it is not foreseeable that you'll be sued in that state because the contact that you have with the state is too tenuous, is too distant, is too minor, if you will. Now, this is a rough skeleton of what your charge should do because there are tons of things that are missing here. What's missing here are a couple of things. Number one, notice nowhere on the chart am I putting the names of cases, which you should. Right? Secondly, if you put names of cases in the chart, at some point you must put certain facts, one-word fact, in the chart so as to give you a hint of what this is about. The idea being that if your chart is constructed, right, in such a way that is really useful, you should be able to look at it and analyze a fact pattern from start to finish without ever looking at your case. Right? Okay. So let's just pretend for now that the answer is yes to all of that. Right? There are two things that we're going to be talking about today. Notice that even if you say that those contacts occur through purposeful availment, that those contacts were foreseeable, as we'll talk about in Ford, it's still the case that it must be shown that the suit that is being brought against you either arise out of or relate to those contacts. Because if they don't, it really doesn't matter very much. Right? But let's assume that they do. What kind of jurisdiction then, by the end of the chart, you'll be able to exercise with that person? Specific. By the time you get to it, if the answer is yes to everything, it's going to be specific jurisdiction. Now, notice I'm still not being very precise, because by the time I get to here, there's a step that I skipped that many of you always point out, and you can put it in your chart as well, namely that by the time you get to the minimum contact test, what you're really talking about is long-arm jurisdiction. You're trying to exercise specific long-arm jurisdiction. And we know that the box that you have to check is that you have to satisfy yourself that that particular form has a statute that is a long-arm statute that is long enough to apply. Because if the long-arm statute is not long enough to apply, you even have to go to purposeful availment. Statutorily, it really doesn't matter. Right? Okay. Any questions so far before we get into McIntyre and Asari? Okay. Yes.
What parts are general jurisdiction then on this chart? I'm sorry.
Well, we begin with general jurisdiction, and general jurisdiction simply means that you can be sued in that jurisdiction by anyone for anything. That is the easiest and simplest way to exercise jurisdiction. And we know that one category of people that can be sued by anyone for anything in a jurisdiction are the people who happen to be the citizen of that foreign state. So that's the part of the chart. It goes all the way down here. That's general jurisdiction. It has nothing to do with long-arm. Okay? The second category, by the way, is presence. You happen to be in the state. We haven't talked about that case specifically. It is assigned, I think, technically for Tuesday. It's a case called Burnham versus Superior Court, in which an individual is married, he separates from his spouse, the spouse takes the kids to California, the person stays in the original state, and at some point the spouse wants to initiate divorce proceedings or want to enforce a particular kind of aspect of the divorce proceeding based on their visitation rights. And the gentleman happens to be traveling in California, right? And while he's traveling in California visiting his kids, he gets served, but he doesn't live in California, and he's not temporarily present in California. And the question becomes, what kind of jurisdiction can you exercise over somebody who happens to be present in a state, even if their presence is really transient? They're simply passing through. What happens if you tag them? It's so-called tag jurisdiction. And one thing that you'll notice in Burnham when you complete that reading is that essentially tag jurisdiction, even if it's transient, turns you almost like a version of a citizen. If in fact I find you in that state and I serve you in that state, you can be sued for whatever I feel like suing. So essentially the two categories of folks who are subject to general jurisdiction, which is the broadest kind of jurisdiction you can exercise, are folks who are the citizen of that jurisdiction and the folks who happen to be present, no matter how temporarily, in that jurisdiction. The only difficulty that you'll have to think about is there's a distinct difference between people who are citizen in terms of human beings and corporations, right? So for example, the fact that a corporation, right, has an office, as we'll talk about later on, in a particular state, doesn't make that corporation a citizen of that state. Right? It doesn't make the corporation present in that state either. Right? A corporation's citizenship is based on its place of incorporation and its principal place of business. So the interesting hypothetical that we'll talk about later on is, but what about if you want to tag a corporation like the Burnham dude was tagged? In other words, if you wanted to say obtain jurisdiction over, I don't know, Facebook, and you wanted to do so in New York, let's just pretend for now that you're not talking about specific long-arm jurisdiction. You want to establish general jurisdiction. Could you get jurisdiction over Facebook because it just so happened you know that Mark Zuckerberg is staying at the Pierre Hotel on Fifth Avenue? In other words, does Mark Zuckerberg, even though he's the CEO of Facebook, stand for Facebook itself as a corporation? So we can put that aside for now. Okay, so what we're talking about here then is, what we're focusing on here then is that part of the chart that we're going to expand, right? So then let's talk about Asahi. Asahi and McIntyre are the same kind of case, and they raise the very same question that over these two cases the Supreme Court majority couldn't decide. Namely, we know we have different examples of purposive availment. One of them is Burger King, right? Asahi and McIntyre are simply examples of what purposive availment is or is not. And the question Asahi and McIntyre raise together is it enough to purposely avail yourself of contact with the state when you merely place an item into the stream of commerce, even though you may have some knowledge or some expectation that the item will somehow find its way into the foreign state? And as many of you pointed out, there was not a true majority in either Asahi or McIntyre for a clear rule of law. But it seems to me, if you put Asahi and McIntyre together, here's what they stand for. Asahi and McIntyre stand for this narrow part of the ruling, namely that the mere placement alone of an item in the stream of commerce without anything else cannot justify jurisdiction over you. And I think every single person in this room, right, understands why that is probably a reasonable. Because if the mere placement of an item in stream of commerce justifies jurisdiction, right, as a business, whether you are large or small, where would you be subject to jurisdiction in the United States? Yeah?
Practically anywhere your product wound up.
Exactly. You would never be able to predict where you could be sued because the moment the item is placed there, right, then it goes in. If you look at the reasoning of McIntyre and Asahi, even if you look at the concurring opinion that Brennan wrote in Asahi, Brennan agrees with it. The only basis of this disagreement is, if it's true you need something more, what exactly is the something more? Brennan would, if you go back to the Brennan's concurrence, and it's very short, he says, well, the something more doesn't mean that the defendant has taken action, the something more can simply be the nature of the commercial activity. That maybe Brennan says that, if you place something in a stream of commerce, there may be circumstances in which we know that you can predict, you are aware that this thing will most likely end up in that forum state. If you look on page 141, the first full paragraph, Brennan says, the stream of commerce refers not to unpredictable currents or eddies, but to the regular and anticipated flow of products from manufacture to distribution to retail sale. And this is the key part of Brennan's concurrence. Brennan says, as long as a participant in this process is aware that the final product is being marketed in the forum state, the possibility of a lawsuit there cannot come as a surprise. So for Brennan, placing in the stream of commerce alone is not enough, because you certainly don't want to expose a small business to jurisdiction everywhere. But the stream of commerce plus, the plus factor to Brennan, is the mere awareness by the defendant that this thing is being sold and marketed in that form. Right? So even though the defendant hasn't necessarily directed the item toward that form state, if the defendant knows it is being marketed there and used there and sold there, that is not. So if you are to take Brennan's concurrence seriously, McIntyre's result is entirely different, right? Because the British corporation knew perfectly well where the tool was being marketed. Right? Now, if you go back to the majority opinion, not the majority opinion, the plurality that O'Connor wrote, O'Connor basically said no. Mere awareness is not enough. You must do something extra. It's not enough that you know. You must take some action in which you basically almost push the product toward that particular. That's basically where the law is right now and where the law remains. Right? That mere placement is not purposive availment. It must be placement plus. The disagreement between the justices is what is that plus thing is. Some folks like Brennan and Sotomayor, by the way, in her letter to Senator McIntyre would say, look, in this modern world where the company knows exactly where the thing is being marketed or sold or used, that knowledge alone should be enough that it would not be a surprise for them to be sued. Whereas other justices such as, O'Connor, at least when she was on the court, and others also, would say no, mere knowledge is not enough, you must push the product itself toward that particular. Is that clear so far? Now, what it means is that by the time you get to this part of your chart in which you're distinguishing the availment, what I'm saying to you is that there remains in the case law some ambiguity and some uncertainty as to the ability to exercise jurisdiction based on the placement from commerce, which means that if I'm going to test you on personal jurisdiction, it's not a secret. That's why I'm going to test it. Right? I'm not going to test it where the law is clear. I'm going to test you where the law is unclear. Right? Okay. Any questions about that so far? McIntyre or Asad? Yes.
So the two kind of competing views as to what the plus is with the stream of commerce theory. So it's O'Connor saying that it's purposeful action, and it's Brennan saying that it's foresight, and it's still just kind of like...
I think so, and even I'm using those names as sort of proxies because you and I both know that O'Connor and Brennan are retired, but if you go and look at Sotomayor's dissent, right, she echoes Brennan. She basically said in the modern world, most manufacturers or distributors, even if they don't actually target a state, are perfectly aware where their thing is ending up. And that awareness should be enough if in fact the product goes wrong. But the majority of the court has resisted that awareness test. They want something more specific. It's almost as if as a manufacturer, I'm making a product, but I know California has a very particular requirement for that product, and I modify that product slightly to fit the California market, even though I'm not selling it to California direct. I'm simply sending that bunch of stuff to a distributor in Michigan. But I think even O'Connor might say, in this instance, when I'm selling the thing to the distributor in Michigan, but I'm selling, say, 10,000 units, of those 10,000 units, 1,000 of them are specifically modified in such a way that they can only be sold in California. Surely that is enough to say that I directed to California. It's not knowledge now, as opposed to say, yes, I'm giving the distributor 10,000 units, and I know as a general rule, some of those units are going to end up in California, but they haven't been modified for California anymore.
On that example, if you create a product, you sell it to another company, they take the modifications to direct it towards California.
They change your product?
Yeah, they change it. They add to it to market it.
I think the answer will still be the same. If I merely know that they're changing my product, I think the sort of plurality view would be that is not enough. Mere knowledge is not enough. If, however, for example, let's just say I don't just know, I instruct them as to how to modify it. Would that be enough?
Would be interesting.
This is one of those instances where the law, and by the way, if you're struggling with that analysis, the one thing that you'll notice is that 9 justices on the court over 2 cases, right, couldn't agree as to what the proper analysis is. This is why I'm laying out those 2 options for you. It's not because I'm saying, well, I'm hiding the ball, or you're not missing anything in the cases if you're not clear exactly where the court is. The court itself is not clear where it is. I think the one thing that we know as a baseline, is that the mere placement of the product in the stream is not enough. There must be a plus factor. It's only the plus factor that disagree with them. Questions? Yes.
On like, for example, on products where they say like, if this product is sold in California, it doesn't have like flame retardants, I think that's something they have to like identify on California products. Saying like, if this has flame retardants and it's sold in California, that markage is like, where would you find that?
What do you mean?
Like saying like, if this product is sold in California, here's a label that needs to be on there if it's sold in California.
I'm the one making the product, and you're the distributor.
Yeah.
And what do I do as the manufacturer of the product? I'm just telling you to put a particular tag on it, or?
It has a tag that's if it's sold in California.
Because California requires it.
Yeah.
And I, as a manufacturer, put the tag on it.
Yeah.
Because I know it's required by California.
Yeah.
But I'm not selling in California.
No.
I don't market in California, right? But what I'm doing is that I'm sending it to you, and you happen to be a Florida company, right? But you sell in California, and you market in California. And the question is basically, can I be sued in California if that particular item causes harm, right? What do you think the answer is?
I think you can be sued in California, that's what I'm saying.
I think in that circumstance, you come close to O'Connor's view that I've basically directed the stream. It's not mere knowledge. I've directed the stream to that. Yeah.
So I guess for O'Connor, is you have to have the plus factor is some action towards the forest. And for Brandon, is just the awareness, right? So
I can't tell you as a policy matter which rule is better, but I think the way that you phrase it is right.
yeah, so does O'Connor's requirement actually entail Brandon's requirement? So
Does it what?
entail or imply, so your action towards the forest doesn't imply you have the awareness.
It seems to me, yeah, because O'Connor's text is stricter than Brennan's text. If you look at it, right? Yes and no.
What if, because it's not uncommon to have like language in something that's like, if this is in California, but it's on all the products. It's like default language that all of them use, but it does include a special characterization for a single state.
Yeah, you're modifying her hypothetical. That makes it a harder question, doesn't it? In other words, what you're saying to me is that suppose in California, as a requirement that is stricter than all other states. So for me as a manufacturer, right, if I abide by California's requirement, I've automatically also followed the requirements of all of the other states. So as a default, basically, I go with the California rule. Essentially, I've made my product essentially good for California, because by making it good for California, I've made it good everywhere. And you're asking me, is that act alone sufficient to subject me to jurisdiction in California? Because the problem, of course, is that if I didn't make it considered in California, I could sell it in every single place except for California. I don't know what the answer is. Is that act alone sufficient to meet? It seems to me it's easy to meet the Brennan test. I'm not sure it would meet the O'Connor test. Yes.
So, excuse me, in terms of in the future when we're looking at hypotheticals and hypothetical fact patterns that might be similar to what we're dealing with now regarding specific personal jurisdiction, what would you like for us to kind of keep in mind, like at the forefront of our mind? Like, should we be keeping, I know you said you don't want to use the specific names because they're retired, but like, should we be keeping O'Connor's opinion in mind primarily because that is technically the law of the land, and in McIntyre as well, like, or should we keep the concurrences in mind? Like, how would you say we should approach
I
that?
think you should keep both in mind. And look, at the end of the day, both the O'Connor test and the Brennan test aim to do the same thing. They aim to answer the question as to whether or not that personal availment that you're trying to decide leads to foreseeability. And Brennan would say that knowledge is foreseeability, whereas O'Connor says it would take action. So essentially what you're trying to do with the fact pattern is to massage it in such a way you're trying to conclude whether or not you can really end up with foreseeability. Now, obviously, if what I'm testing is a multiple choice question, right? I would never test a multiple choice question in which A, B, C, and D, that both A and B could be correct. I have to test it in such a way only one of them is correct. However, the way I would test that proposition is not in multiple choice question, but in an essay question in which the final answer that you give me, whether there is jurisdiction or not, is less important than the analysis that you engage in. So in an essay scenario, I would actually give you credit for the fact that you are aware of both parts of the test, you're able to apply them to the facts, and you exercise a particular judgment to reach a conclusion that I may or I may not agree with, but I cannot disagree with the analysis. I think there was someone in the back right there. Before we move to sort of getting deeper into the question of general jurisdiction or not, is anything that I've said so far unclear? I understand that the chart that I've put, as I said, is a skeletal chart that you're supposed to expand, right? But I just want to make sure that I've answered any questions you have before we move.
Just a follow-up question. So you said awareness is also automated by O'Connor, right? And why the minimum consensus doesn't include the awareness part?
Because O'Connor doesn't say awareness is enough. She doesn't admit it's enough. O'Connor says that awareness, in fact, O'Connor says the opposite. O'Connor says that if all you bring to me is the knowledge by the company that their item.
Yeah, but you said the minimum consensus is merely placing into the stream of knowledge. It's not. Can we say also with okay, yeah.
Yeah, merely placing it, that's the flow, if you will. The placement is the flow. Think about it this way. Let's very briefly, I have to make sure that's clear. Pay very close attention to the facts of Asahi as the majority described them on page 134 on the women more one, right? Changshen manufactures the actual tube that went inside the wheel of the motorcycle, right? And they do so in Taiwan. In addition to that, Asahi manufactures the actual valve that is used to put air into the tire. In order to manufacture the tube, Changshen gets the valve from Asahi, assembles everything in the tube. That tube then is sold, presumably, to, let's just say it's Honda, motorcycle company, right? And puts in a motorcycle. When the plaintiff gets injured in California, the plaintiff sues the motorcycle manufacturer, let's call it Honda. They sue Changshen, right? And they sue Asahi. And part of the reason is that the plaintiff knows that the tire basically exploded, but maybe it's not entirely clear at the start of the lawsuit whether or not the flaw was in the valve itself, or whether the flaw was when Asahi put the valve together with the tube, or whether or not Honda was aware that there was a problem but never fixed it. Right. We know that by the time you get the opinion, the writer has basically settled and dismissed the original lawsuit. Right? Okay. The only problem is that when Changshen and Honda and Asahi were together as defendants, right? In addition to the plaintiff suing them, they were also making quote-unquote close claims against each other, right? So the only issue that was being decided here was, okay, if Changshen made a cross claim against Asahi, right, and the case is in California, then what we have to decide here is the contact made by Asahi with California. And what we have to decide is the question of personal availment. Now, we don't have to pretend because the court itself acknowledges that. Every single one of these players, be it Changshen or Asahi, knew perfectly well that their product, be it the valve or the tube, eventually was going to end up in California. Right? So the only question is whether or not, for example, when Asahi put the valve together with the tube and sold the tube, right, to a whole bunch of companies making motorcycles, whether or not Asahi had done anything to specifically direct their product, the tube, toward California. That's it.
To California, that doesn't mean to the United States in general, that just means specifically.
Exactly, just specifically to California. But is there any doubt in your mind that Honda was subject to jurisdiction in California? No. Because it doesn't matter whether or not Honda was incorporated in California. It doesn't matter whether or not Honda had its principal place of business in California. Even though the facts are not very clear here, you know perfectly well that if you wanted to do a minimum contact analysis, it would be child's play to subject Honda to specific long-arm jurisdiction in California. That's not even a close call. Assuming, of course, the long-arm statute is long enough, it wouldn't be a close call at all.
So, in Asahi, they also say that they just like add on the end that the burden would be too high to bring them to California. They've been there in Japan and really Changshen is in Taiwan. But it seems to me that if it's about the stream commerce plus theory, why are they even saying that? Like, why are they even talking about the burden?
It's not the first time that you'll encounter that phrase, because the court says the same thing in Volkswagen, in a bunch of other cases. And I think I may have mentioned this to someone either during office hours or in class. the burden thing is something that the court sort of tacks on at the end to sort of bolster its analysis, right? The burden thing is another way for the court to go back to the fairness question, that somehow it'll be too burdensome for you to litigate in California, and therefore it is unfair. But the real analysis is not there. The real analysis is whether or not it is foreseeable for you to do. All the court is doing with the burdensome thing is to simply talk about the question of justice and fairness and fair play. I think there was some question in the middle of here. So then let's talk about Goodyear. Let's just put the facts on the table so we can concentrate on the holding of the case. Right? An accident occurs in France on a bus transporting a bunch of kids who were on a trip to play soccer. Two of the kids get killed. Right? The parents of the kids, who are citizens of North Carolina, bring a wrongful death lawsuit in North Carolina, and they sue a number of defendants. They sue Goodyear Tire, based on Luxembourg, their Luxembourg division. They sue Goodyear Tire Turkey division, and they sue Goodyear Tire's France division. In addition, they sue Goodyear Tire USA. Now, each of these divisions, for now, I want you to accept as a given, even though they are related to the main company, are in fact separate and independent entities. Right? Now, it turns out that the actual tires that were on the bus that caused the accident were not manufactured in North Carolina. They were not sold in North Carolina. Right? That much we know, right? There's also something else that we know. In addition to the tires not being manufactured in North Carolina or sold in North Carolina, is that neither Goodyear Luxembourg or Goodyear Turkey or Goodyear France have ever advertised in any way in North Carolina. But if you read the facts of the case very carefully, there is one set of facts that seem, according to the opinion, bring into contact, right, the various defendants with North Carolina. What was it?
Some of those tires from the Luxembourg, Turkey, and France subsidiaries made their way into the U.S., I believe.
And did they make their way into the U.S. generally, or did they make their way into the U.S. and end up in North Carolina? Yeah.
Wasn't there some sort of like machine employed by North Carolina that only used like French measurement tires or something like that?
There were some special vehicles, including work vehicles, that those tires were specialty tires that were manufactured by these defendants and happened to go to North Carolina. Like, for example, you would have a special tractor, for example, that only uses a particular kind of tire, and you ordered it, it was manufactured in those other places that were being sued and sent to North Carolina. Right? So that was the question. But the plaintiff then wants to get jurisdiction in North Carolina against Luxembourg, France, and Turkey. Now, let me ask you this question. What kind of jurisdiction were the plaintiffs trying to assert against Luxembourg, Turkey, and France?
General.
Okay, they want to have general jurisdiction. Why couldn't they exercise specific long-arm jurisdiction? Assuming for now, I want you to accept as a given that North Carolina had a long-arm statute that was long enough to reach Turkey and France and Luxembourg. Why couldn't they simply say it's specific long-arm jurisdiction?
claim didn't arise or relate to an action for the defendant that was directed at the state.
Okay. So essentially, if you were to go through the specific long-arm jurisdiction analysis, you would ask yourself, did Turkey, I'm using Turkey, France as shorthand for Goodyear division, did Turkey, France, and Luxembourg purposely avail themselves of contact with North Carolina? Is the answer yes or no? Generally speaking, think about it. Did those three entities take action on purpose, voluntarily, to contact the state?
Yes.
Okay. Yes, every time they sold one of special tariffs, right? Okay. Is it the case that those contacts were such that they might anticipate being sued in North Carolina? Not about this, but what else?
There's no relationship between the plaintiff's claim and that state and the contact that they have.
Exactly, but notice that if you were simply answering the question, in the abstract, you would say yes, personal availment, and yes, you might expect to be sued there, but only if you're being sued for the things that you're selling in that state, right? But you wouldn't expect to be sued there because a tire exploded on the way to the airport in Paris when the tire was never manufactured in North Carolina, it was never sold in North Carolina, you've never done any sort of advertisement in North Carolina, right? So therefore, the reason why the plaintiff is going after general jurisdiction is that the plaintiff knows that they will never be able to pass the test, right? For general long-arm jurisdiction. And why is it general long-arm jurisdiction as opposed to general jurisdiction?
Long-arm statute that you mentioned.
Yeah, because we cannot make them fit here, we cannot make them fit here, right? Because here and here is the general jurisdiction. But the moment that you do not have these categories, and therefore you have to go to some sort of contact analysis, right? Then it becomes general long arm as opposed to general jurisdiction overall. Yeah.
Is general long-run jurisdiction only for corporations?
What do you mean?
Like, that cannot be exercised for like individual people.
Give me an example.
I don't. I just mean like if someone's trying to sue someone else that wasn't in the state, but it's the I don't know.
Well, I think the answer will become clear once you finish going through the other cases, right? Because once you pass Goodyear, and I'm going to go back to the statement that Goodyear made, there are at least two other cases that I want you to think about and read carefully, even if you don't spend a lot of time in the in class, because they are designed as examples. The one is the Daimler case on page 167. Daimler is a German corporation. The plaintiffs, right, are victims and families of victims in Argentina, right, saying that the Argentinian regime engaged in various forms of torture and abuses of the victim, right? They are trying to get jurisdiction over Daimler in California, right, based on contact that Daimler had in California in terms of selling cars in California. So here's the question for you. Could you have gotten specific long-arm jurisdiction over Daimler in California, even if Daimler is not incorporated in California and doesn't have a principles of business in California, on the bare-bone facts that they describe in the case? How confident would you be if, in fact, you wanted specific long-arm jurisdiction over them? Would you do it? Another way of asking questions is that what kind of specific, under what circumstances could you imagine having specific long-arm jurisdiction over that German car company in California? Maybe the reason why you're hesitating answering the question is because the answer seems so obvious. Right? Yeah.
Is it if they sold those cars in California?
And the lawsuit was about what?
It was
Think of
foreseeable
Ford.
that they would be brought to, they could potentially be sued in the state for those.
Yes, and what is the last part of the test that Ford makes it clear? That the lawsuit arises out of and relates to their action in California. What was the lawsuit? Did the lawsuit in California against Daimler have anything to do with their selling cars in California? Exactly. So that was another example of general long-arm jurisdiction. But maybe the case that will make it even clearer if you skip ahead and look on page 170, BNSF Railway versus Terrell. Railroad workers sue a railroad, right, in Montana State Court for injuries that happened to them outside of Montana. The railroad maintained tracks in Montana. So the only basis of their trying to assert jurisdiction over the railroad in Montana is the fact that the railroad basically runs railroad through Montana and passes rail cars through Montana. But the basis of the lawsuit is an injury to the workers that occur completely outside of Montana. So the question here becomes, well, can you obtain specific long-arm jurisdiction over the railroad in Montana? Well, it would be fairly easy to do so if, in fact, the reason why you were suing them had to do with what they were doing in Montana. But the moment it had nothing to do with what they're doing in Montana, then you have to try to get general long-arm jurisdiction on it. Right? And the reason why it has to be general long-arm jurisdiction because they're not incorporated in Montana, and they don't have their principal place of business in Montana, even though they do business in Montana. Right? Yeah.
But a general jurisdiction is only where you are domiciled or you have a headquarters. And how could you get general long-arm jurisdiction? Like how would that work?
It doesn't work.
Okay.
It never works. Right? So, for example, based on your reading of these cases, how many times have a court, has the Supreme Court ever agreed, right, to exercise general long-arm jurisdiction over a non-resident, non-present corporation in a foreign state? Yeah.
Once in Perkins.
Okay. What happens in Perkins? What happened? Do you remember?
It was like a foreign corporation that moved like during World War II to the US and operated there for like years as their
Exactly. It was a Philippine corporation. They moved to Ohio. The president of the corporation moved there. They did all their business there. Now, what is the test for general long-arm jurisdiction? Because the court does announce a test as to the circumstances under which you may exercise not general jurisdiction, which we know is these people and these people, but general long-arm jurisdiction. The court announced the test in Perkins. The court repeated the test in Helicopteros, right? And in subsequent cases, including Goodyear, the court re-explains the test and explains why it doesn't apply to the test.
Is it, if they're like essentially at home?
Yes, that's exactly. It may sound vague, but that's essentially what it is. You have to be essentially at home in the place where you're being sued, even though you're not a citizen of that place, you're not incorporated in that state. And your colleague is right. The court has only found that once. It has never, ever, ever found it again, no matter how many times people try to make it. So let me ask you this. Supposing in an exam scenario, I give you a multiple choice question in which one of the answers, right, one of the options is general long-arm jurisdiction. What do you think is the likelihood that that option is ever the right answer? There you go. That's the So in other words, we don't need to spend a long time on this. It's almost never the right answer because the court simply doesn't permit general long-arm jurisdiction. It found it once in Perkins and has never found it ever again. And every single time it writes about it, it reminds the plaintiffs that this is not a serious thing. In other words, and we're going to get to that case in a moment. If I told you, as you know for a fact, that Ford had hundreds, if not thousands, of dealerships in Montana, that Ford sold bazillion parts in Montana, that Ford ran tons of advertisements in Montana, that Ford sold tons of cars in Montana, that Ford even had satellite offices in Montana, would Ford fit the Perkins test?
In like the Dahmer case, they kind of point out that if your presence is so established everywhere, then you can't be essentially at home everywhere. Like it's only in kind of in the inverse way.
Exactly. In other words, it doesn't really matter how extensive a company's presence, right, is in a particular foreign state. It doesn't matter how much money the company makes from that foreign state. You should never be tempted by the idea that that company is ever essentially at home in that foreign state for purposes of general long-arm jurisdiction. So, let's go back to your question, because your question to me was, is it possible for an individual, as opposed to a corporate entity, to ever be subject to general long-arm jurisdiction? What do you think the answer is? Just doesn't work.
What would be, if you're essentially at home, like if that standard is met, isn't that very similar to like it being your principal place of business? So wouldn't that be the same?
It's like it almost collapses into it, because if you look at Perkins very closely, the dude that basically moved his entire operation from the Philippines to the US, he just had never bothered to reincorporate his company in the US and never declared his office as being principal place of business. But for all intents and purposes, it's almost as if the essentially at home test is another way of saying that you might as well be incorporated there. And I think this is a unique situation where essentially this person had become almost sort of rootless, if you will, the company. Since it was in the middle of the war, they had never incorporated into the US. It's almost as if you're saying, this is your principal place of business, but if it's your principal place of business, you're a citizen. And if you're a citizen, you're subject to general jurisdiction, not general long-arm jurisdiction, right? Yeah.
If a corporation just does not have a headquarters, and the only place that can be found at be where they're incorporated, like if you are suing a multi-level marketing scheme, they don't have a headquarters anywhere and they like operate completely over Zoom, but they're incorporated in Delaware, they're only at home in Delaware.
That's a great question, which I'm going to ask you to answer yourself once you do the readings, and you haven't done it yet because I haven't assigned it to you, when we get to subject matter jurisdiction. Because one of the key questions for subject matter jurisdiction is, how do you know where your principal place of business is? Is it where you make the most money? Is it where you have the most employees? Or is it where the decision making is made? And the test that you'll come across eventually is that the court says the principle of business is the nerve center of the business. It's where the decisions are made. So whoever is making the real decisions in the multi-level marketing thing, whoever is the head person, that's where the headquarters is. It doesn't matter what it is. Okay? Any other question? Yeah.
I'm a little confused about the two concepts.
Which concept?
General jurisdiction and general long-arm jurisdiction. So what's the relationship? Is general jurisdiction contains or include general long-arm jurisdiction?
That's one way of think about it, but I don't want to visit that because I think it may muddy the water a little bit. General jurisdiction is the broadest kind of jurisdiction you can have. So by definition, general jurisdiction is this: the entire universe of what you can be sued for is it. Right? Now, to say that you have general long-arm jurisdiction, it's not so much that it is contained within general jurisdiction. It is simply a different category of general jurisdiction that doesn't exist, if you will. Because general jurisdiction is the ability to sue somebody for everything, period. Right? And the only times you can do it is if the person is a citizen of the state or is president of the state. General long-arm jurisdiction is the ability to sue somebody for anything and everything, even if the lawsuit has nothing to do with what happens with their contacts in the state. And that the court says you cannot do. Yeah.
Can an individual be a citizen of multiple states?
A person with American citizenship alone cannot be a citizen of multiple states. A person can have multiple residences, but the person's citizenship is based on their domicile, as we'll talk about. And if this is not clear yet, it's because we haven't really covered it yet. This is really covered more explicitly in subject matter jurisdiction. So you can have multiple residences. It may very well be that you have a condo in Central Park, was in New York City. You own a beach house in Malibu. You have a vacation home in, I don't know, Bar Harbor. You have multiple houses, right? It doesn't make you a citizen of every single of the state where you have a house. For me to know where you're a citizen, I have to fix your domicile. And domicile is different than residence. So an American citizen can never be a citizen of multiple states. However, of a non-American citizen, or can, I shouldn't say that, a person can have dual citizenship, right? American and non-American, and that becomes a subject matter, a problem for subject matter jurisdiction. It doesn't matter for personal jurisdiction.
I'm skipping ahead a little bit, but I'm trying to understand how general jurisdiction and consent by registration play into one another, and I guess what exactly constitutes registration.
We'll get to that. Okay. So let's at least focus on this issue of general jurisdiction and make it clear. Ford versus Benderman. Facts are very simple. Ford is a Delaware corporation. Its principal place of business is in Michigan. To answer your question, Detroit, Michigan is not where Ford has the most employees. It's not. There are very few employees of Ford left in Detroit, Michigan. Detroit, Michigan is not where Ford manufactures most of its cars. As already explained, Detroit, Michigan is not where Ford gets most of its money. The only reason why Detroit, Michigan is the principal of business of Ford, it's not because Ford says so, it's because that's where most of the top CEOs of Ford are still headquarters. So that's the reason Ford, that's a perfect example. So Ford incorporated in Delaware, principal business in Michigan, right? What happened in the case, you have two instances in which an accident occurs, one involving a car in Montana, the other one involving a car in Minnesota. Neither one of these cars, right? Neither one of these cars were sold or manufactured in Montana or in Minnesota, right? In fact, one of the cars, well, both cars were designed by Ford in Michigan, right? One of the cars was manufactured in Kentucky. The other one was manufactured in Canada, right? neither one of them was sold in the state where the lawsuit was being brought. One of the cars was sold in Washington state, and the other car was sold in North Dakota. So if you were thinking about it in terms of specific jurisdiction, right? Technically speaking, Ford could be sued in terms of general jurisdiction in Delaware and Michigan because of this. In addition, with respect to the cars themselves, then Ford could also be sued for specific jurisdiction, Long Arm, Henderson, Long Arm, because they're in Michigan because the car was designed there. But it could also be sued for specific long arm jurisdiction in Kentucky because one of the cars was manufactured in Kentucky. But it could also be sued for specific long arm jurisdiction in Washington state for the car that was involved in the accident. And it could be sued in North Dakota because the car was presumably sold in North Dakota. But what happened here is that both cars were actually sold outside of the state where the lawsuit was being brought. Right? And what was the only reason why the lawsuit was brought in those states, Minnesota and Montana? Yeah.
The owners of the cars that moved to those states and take the cars with them.
And the accidents happened there, right? Okay. So Ford's argument was what? Why did Ford say that they couldn't have specific jurisdiction? Yeah.
Because it didn't have to do their branches within the states.
So basically, Ford is saying that if a car was involved in an accident in Montana, and you want to sue me for that accident in Montana, then you must show that I sold that car in Montana. If a car was involved in an accident in Minnesota, then you must show that I sold that car in Minnesota. Right? And the court says no. I can still exercise specific long-arm jurisdiction over you, even though in Montana, even though you didn't design the car in Montana, you didn't manufacture the car in Montana, and you didn't sell the car in Montana. Why?
Does Ford still purposely fail to sell to those markets where the accidents happen, selling those specific types of models of cars? So it could be foreseeable for them to be held into, of course, in that state of a lawsuit or as the end of accidents involving that model car in that state. Okay.
Interesting point. Did you notice in your reading the opinion, the court's discussion of World Volkswagen? Remember, when we talked about World Volkswagen, I kept asking you to focus exclusively on the dealership, Civil. But we also talked about the fact that there could be other defendants in the case, namely Audi, right, that literally manufactured. Did anyone notice whether this court said anything about, say, the ability of the plaintiffs in Worldwide to exercise long-arm jurisdiction in Oklahoma against Audi?
They said essentially that since the court doesn't make mention of it, they're implicitly supporting that interpretation.
Okay, what else?
And that therefore it's clear that they could exercise it. As if they couldn't have, then the court would have said as much.
I'm sorry, I think you were about to raise your hand.
Oh, yeah, I was just gonna say it's the fact that there's a reciprocity.
What do you mean?
The fact that in Oklahoma, Volkswagen was getting benefit from having their business and their product there.
You're both right. The court essentially does a little bit of a long minimum contact analysis with Audi and Oklahoma because the court said, look, you are selling cars not just in the US, but you specifically sell cars in Oklahoma. You probably advertise in Oklahoma. right? You may have dealerships in Oklahoma. The fact that the accident occurred in Oklahoma using a car that wasn't sold in Oklahoma doesn't matter. The nature of your actions voluntarily taken in Oklahoma is such that they indeed relate to the lawsuit. Same thing with Ford. So the relatedness test is this. What actions is the defendant taking in that particular state? And is it the case that that lawsuit arises out of the same kind of action that the defendant is taking? Think about Keaton magazine, Keaton versus Hustler magazine. Right? What was the nature of the lawsuit? How did it relate to the specific type of action that Hustler magazine was taking? Yes?
Yes, they were selling magazines in the state and
Exactly. So the court is saying there doesn't need to be a one-to-one relationship between the item itself and the lawsuit. The question is that Ford is being sued because an item that it designed, manufactured, sold, right, and promoted, right, harms somebody in that state. And even though that specific item wasn't actually designed in and sold in that state, it's still the same kind of item that actually caused the harm. So this is the last part of your chart that you have to account for, right? That did the defendant previously avail themselves of those contacts? Are those contacts such that the defendant should reasonably foresee that they might get sued in that state? And is it the case that the suit relate to or arise out those contacts in that state?
So how would you distinguish the line between when it does relate and arise out of the actions that occurred and when it doesn't? Because in the prior example with the tires,
Yes!
it was said that it wasn't.
Exactly, that's exactly what I was going to ask you.
Yeah.
Why is it that in Goodyear you couldn't say that in fact it related to an arise out of, because Goodyear, Turkey, and Luxembourg and France sold tires in North Carolina. Maybe not those particular tires, but they sold tires, yeah.
I think it has to do with foreseeability of, like, they had an established market and advertisements, and like you said in the, like a few minutes ago, it doesn't matter how many ads they ran or like the extensiveness of their operations there, but someone in Montana could have seen an ad for a Ford, went and bought one, and regardless of where it was made or where it was sold, brought it to Montana. So like the foreseeability of someone seeing an ad, being motivated, and that is what Ford want. They want Montana residents to buy their cars, so that's where the foreseeability comes in, I think, and that's why it's related.
I have no idea, that's why I asked.
Yes, sir, I'll come to you in a moment.
The court points out that they literally promoted the purchase of like used vehicles in those states, and on top of that, the exact same vehicles that were involved in accidents. So there's like a direct connection to those vehicles and the accident that happened, which in the other case, the tires are different in the different states. So like they're tires, but they're not the exact same tires. These are the exact same cars.
I mean, that's important also, right? The court does you right, absolutely right. It's right. That, you know, the Crown Victoria, the Explorer, you know, Ford was in the business of making sure that their dealerships also sold used cars, and they were promoting the sale of used cars. Yes?
Is it impactful that the action happened in France and not in the state? Like in the case with Ford, the accident happened in Montana versus France.
I mean, yes, it is important where the action occurs, I suppose, right? But notice that Ford could have been sued in a state other than Minnesota, or Montana would occur, and in a state other than Michigan or Delaware, where it is incorporated under the principles of business, right? So sometimes it matters where the action occurs. Sometimes it does not. But may I complicate this a little bit, because I think before we take a break, because I think here's an important question. Where does Bristol-Myers Squibb fit in all this? Remember in Bristol-Myers Squibb, right? The drug company makes a drug. Suppose there's something wrong with it. The drug is sold in California, but it's also sold in a bunch of other places, right? A lawsuit is brought by a bunch of plaintiffs in California, some of whom live in California, and some of whom bought the pills in California, ingested the pill in California, and got harmed by the pill in California, right? But then you have a group of plaintiffs who are part of the same lawsuit, who did not buy the drugs in California, didn't ingest the drugs in California, and were not harmed by the drugs in California, but rather bought, ingested, and were harmed by the drug in some place other than California. And the court refuses to permit those plaintiffs to be part of the case and to exercise jurisdiction over the company. How does that square with Ford and with Goodyear Tire? Yes.
I think there needs to be a specific affiliation between the forum and the controversy. For the Goodyear case, forum being North Carolina, the controversy being France, there's not a connection.
So maybe that answers your question that you asked me a moment ago about how impactful it is for there to be, that the action itself must have taken place in the state. But notice that I kept insisting from the very beginning that all that matters for purposes of long-arm jurisdiction analysis is that you have to focus on the action that is taken by the defendant, because you're concerned about the fairness of the defendant. So what does it matter here that the plaintiffs themselves, who didn't have any relationship with California? Why was it unfair, presumably, to exercise jurisdiction over Bristol-Myers Squibb in California? Does that make any sense? You're all there. I'm focusing on these cases because, and we'll take a break in a moment, because as I'm sure you'll note, the consent and contract cases we can dispose of very quickly. Yes, sir.
Was it because it was the state and the defendant's activities lacked connection to the plaintiff's claims?
In some sense, then, what the court is doing, you're right, is that the court is not really focusing on the plaintiffs. The court is saying this: what is being exercised over the company cannot be general long-arm jurisdiction. Right? Because we know that general long-arm jurisdiction almost never happens. So it's either you're able to exercise general jurisdiction over Bristol-Myers in California, in which case you can only do so if it's a citizen of California who is present there, or you're able to exercise specific long-arm jurisdiction over Bristol-Myers in California. And the question for specific long-arm jurisdiction is that, did Bristol-Myers Squibb, right, purposely avail itself of contact with California such that it could have foreseen being sued in California by people who bought the drug in New York and got harmed in New York? See, part of what the court is trying to avoid here, as it says in the opinion, is the issue of forum shopping. In other words, the court is trying to avoid an instance in which the parties are suing a particular state, not because the state has any connection to the problem, but because maybe the state has the advantage of having a particular law. In other words, they're trying to do what Keaton did with Hudson Magazine, except that Keaton was able to establish the connection in Wizard. So I've taken, it's 1:55. Let's take a 5-minute break, come back at 2, because I really do want to cover the contract and registration process. This was an class of people in multiple places in one. That's not imagine like this, there were 20 It was a system that was worked a long time ago. There's 10 different cases. folks. Welcome back. How are you doing? Hello. Let's try to finish those contract cases. Alright. You recall that I mentioned at the very start, in constructing your chart, you will inevitably have to sort of redo it. So, we're going to cover three very quick topics about jurisdiction. One is about appearance, one is about consent, one is about registration. So essentially, where we're going now with the chart is that even before we get to the complicated thing of long-arm jurisdiction, it may very well be that by the time you get here, whether the person is present, and the answer is no, the next question is not long-arm jurisdiction in contact, but has the person consented to jurisdiction, right? And there are three possible categories that we're going to talk about. So my first question to you is this. Supposing you get sued, right, in a particular jurisdiction. Since you and I know you have it's not a good idea to simply not respond, right? Do you consent to the court's jurisdiction if you merely show up to that court to respond to the complaint? Yeah.
You'd like have a special appearance to reject that the court has.
Remember when we talked about Federal Rule 12B, and I asked you to look at 12B, and one of the Bs, and we had that chart on that line on the board about the nature of an action. It was the pleadings. The plaintiff files the complaint against you, right? And you answer or you move to dismiss. One of the ways you can do it in your answer is simply object to jurisdiction. So the mere fact that you appear in court doesn't mean you consent to jurisdiction. But what aspect do you consent to them? Yeah.
Consent to the court's finding if they decide that they do have jurisdiction over you.
Or you certainly consent to engaging with the court, right? In terms of determining jurisdiction. So what was the problem in Insurance Corps of Ireland? What was the problem in that instance? Yeah.
They were claiming that they didn't have jurisdiction, but to figure out if they did or not, the court sanctioned documents, and they refused to handle it.
Exactly. So in other words, for purposes of your chart, the mere appearance in court doesn't grant the court jurisdiction over you, though it does grant the court jurisdiction to determine if it has jurisdiction over you. Right? But what happens if you appear in court, right? You answer the complaint, right? You don't move to dismiss, and in your answer, you do not object to jurisdiction. Does the court have jurisdiction over you? Yeah.
Yes, it does.
Yeah. So that's one form of consent. If you're thinking about consent, that you can consent to the court jurisdiction if you fail to properly object or you fail to timely object to the jurisdiction. Okay? And when we get to the pleading part of the course, we'll talk in more detail about when you can properly object. But one form of consent is the failure to properly and timely object. So let's focus by now. Let's skip for now, right? Let's skip for now the issue of registration. Let's get to contract. Right? What is the basic rule that we can take from the few cases in the casebook? And there are really very few of them. They only appear at the bottom of page 197 and on page 199. Can anybody explain to me, for purposes of the chart, what is the rule of personal jurisdiction by contract? Yeah.
Essentially, if you agree to a certain form in a contract that supersedes all minimum contracts necessary.
Exactly. If you agree to jurisdiction, you agree to jurisdiction. The court is not going to engage in a deep and long analysis as to whether or not it is fair, or whether or not you read the contract closely enough, etc. Right? Because let's take the example of Carnival Cruise, which is the best example. A couple buys a cruise, not directly from the cruise company, right, but from a travel agent. Right? They pay the fare to the travel agent, and the travel agent forwarded the money to the cruise company. Right? Then the cruise company printed the tickets and then sent the tickets to Washington State, where the plaintiff is located. On the back of the ticket, there was language that is included in all the tickets, right? That if in fact anything happens that is wrong with the cruise, any dispute you have, right? That dispute shall be litigated in Florida to the exclusion of all other jurisdictions, right? So the plaintiff boarded the cruise in Los Angeles, in California. They sailed to Mexico. At some point, they slip and get injured, right? But instead of suing in Florida, they basically sue back in their home court, which is why the case ended up in the Ninth Circuit, since Washington State is covered by the Ninth Circuit. And the question becomes, should the court dismiss the case? Because not only had there been a contract that said Florida is the personal jurisdiction, but excluded jurisdiction from excluded every other court from jurisdiction, personal jurisdiction. And the court said yes. And notice that the contract wasn't even directly between the plaintiff and the cruise company. The plaintiff actually had interaction with the agent. The agent sent the payment to the cruise company, and the only contact the plaintiff had with the cruise company was when they received the ticket in the mail, and they basically bought it the cruise. So the basic lesson for this is that one of the easiest ways to basically establish personal jurisdiction is through a jurisdiction clause in a contract. And when you put a jurisdiction clause in a contract, the court is not going to look behind it, and the court is not going to engage in any sort of, minimum contact analysis. Okay? Any questions? Yes.
That's for specific jurisdiction?
Well, that's a good question. By definition it is, right? Because, when you have a jurisdictional agreement in Apple's service agreement, what are you agreeing to? What is the what is the thing that you're saying you're agreeing Apple can sue you for? Or you can sue Apple for, whatever it is. It's the thing itself that you're signing. In other words, the cruise company is saying, if there is any problem with this cruise, if you have any issue with this cruise, I can be sued here. So it's not as if you sign in a contract to be sued for anything. You always sign a jurisdictional contract for something that you're engaged in. So by definition, it's a form of specific jurisdiction. Yes, sir.
Is there any difference to adding in the clause to the exclusion of all other jurisdictions, or just saying all suits must be litigated in this state is enough?
I'm sorry?
Is there any difference to if you add in the clause that it's to the exclusion of other jurisdictions, or you can just say that all suits must be litigated in this forum is enough?
I mean, it can be both. It can do both, I suppose. What happened here is that you can cover yourself by making sure that this suit can only be here, can be litigated. You agree to be subject to jurisdiction in Florida, and you exclude every other jurisdiction.
You subject yourself by contract to general jurisdiction?
How?
By saying I agree to be subject to general jurisdiction, I guess.
But for what though? In other words, I'm trying to imagine a circumstance where you would sign an agreement and you would have a contract clause in a jurisdiction clause in the agreement where you agreed to be sued for anything.
I'm not saying it would make sense. Let's say it slipped in there and you didn't read the contract.
I've never seen one.
Okay.
Because usually, by definition, it always is you agree to be sued if something goes wrong with the thing that we have entered into a contract with. I mean, I hesitate to answer your question because I hesitate to say it's not possible to do. What I can say is that I've never seen it. Yeah.
So like tactically, in like a real case, if you were like, does it make any sense to like challenge something like this that like you know is not gonna work? Like would that ever make sense to do without like annoying the court or something?
By now, it's not the sort of argument that you would make unless there's something extraordinary. In other words, personal jurisdictional clauses in contracts are presumed to be enforceable. And the reason why is, unlike subject matter jurisdiction, which has to do with the power of the court, the rights that you have, right? The rights that you have for purposes of personal jurisdiction are rights that flow to the defendant, right? The fairness is about the defendant being forced to go into court. If as a defendant, you agree to it, what you're really doing is that you waive, essentially, the due process requirements of the Constitution. You say, I'm agreeing to submit myself to your jurisdiction. Let's not talk about due process. Let's not talk about fairness. And the court has decided that these clauses are enforceable, period, are per se enforceable. Yes.
How come the court is so particular when it comes to personal jurisdiction for, like say, minimum contacts, and there are all these tests about trying to get to fairness, whether or not it's fair. But when it comes to consent to the contract, it's just kind of a blanket. If there's a contract, it's fine. Where they don't consider like, well, nobody reads the applicant terms and conditions, like you mentioned. Like why isn't that considered as fairness if they know that people aren't reading these things? It's just a blanket, well, you signed it. Whereas in other circumstances, they're so particular, like, if you knew it was going there, but you didn't design it for California, then that's not fair. But in this case, they just don't.
Well, in some ways, I can answer your question. Who do you have for contract?
Commissioning?
What are you covering? What topic are you on so far?
Mutual assent.
So consideration, that's what you're not yet, okay. One of the things that you'll probably talk about very briefly is that your inability or unwillingness to read the tone of the contract is never a defense for not enforcing the contract. So in some sense, what the consent provision has to do is less to do with civil procedure than simply a matter of contract. In other words, courts don't usually see it as a defense that the contract was too long, was written in tiny language, or nobody reads it. So when you're asking me what's the difference between simply consenting a contract and the court being so particular about whether or not you purposely availed yourself, is because one is a constitutional analysis, the other one is a contract analysis. The court is not really engaging in constitutional analysis in that case. It's simply saying, did you enter into a contract? Yes. So what do you want from me? You signed it. I didn't tell you to sign it. That's just what's going on.
Is indemnification a tool that can be used to escape contractual jurisdiction?
In what sense?
There are some landlords in certain states that practice like predatory leases where they include an indemnification clause where you basically are signing away any rights that they are liable for any injuries, or that you would have to pay attorney's fees and the like for any cause of action that comes against them, which is like essentially a blank check that someone would agree to. Is that a tool that?
I mean, it can, but again, I think the question that you raised, just like your colleague's question, is really one not that is governed by state pro, but rather by contract. There are instances where the clause is so onerous that the relative power dynamic between the parties is so unbalanced that the requirement of the contract seems to be so strict that it becomes what is called a contract of adhesion. That the entire contract itself is so unreasonable, the terms by which it was negotiated or not seems to be so unfair. The party that signed the contract was in such duress that we're going to deem the contract itself unenforceable. But again, that goes much more to contract law rather than CPR. Yeah.
So it is possible to opt out of every jurisdiction if the party to a contract agree to do so, right?
When you say to opt out of every jurisdiction, you mean can I write a contract pursuant to which I cannot be sued anywhere, say in the United States, if in fact there is a dispute? The answer is yes. In fact, that's what Zapata is about, right? You had a contract between two parties, a German corporation and a US corporation, right? The contract provided that any dispute had to be litigated before the London Court of Justice. Something happened when the boat got damaged, and they tried to sue, right, in federal court in Florida. And one of the arguments that they made is that it's unfair that they had a contract that determined the London Court of Justice was the proper forum to litigate the case, and it excluded all jurisdiction in the US. It was unfair for them to have to travel over, and the court said they don't care, right? There's no guarantee that you're entitled to a forum in the United States if in fact you give it up.
Yeah, I'm personally thinking about alternative dispute mechanism where no courts are involved.
You can do that too, and that happens all the time. That's one of the key things that the court decides. Generally speaking, in other words, you could enter a contract in which you agree, and in fact, all of you in this room have agreed to such a contract, by the way, particularly with your credit card company, that if you have a problem with credit card company, you cannot sue them in court. You have to agree to arbitration, and you have to agree to binding arbitration, which is not a court, which is a private organizational entity that is empowered to decide your case. And when the case gets decided, right, by law, they can enforce it in court. You cannot agree. You know? Classic example is Judge Judy. I'm serious. Judge Judy is a show pursuant to which the parties sign a contract in which instead of going to real small claims court, they argue to submit themselves to an arbitrator who happens to be Judge Judy, even though she wears the robe. So what you see every day in Judge Judy is an arbitration. And once she makes a decision, by the way, even though it's a TV show, it can be enforced. You cannot say, well, it doesn't count, it was on TV because you signed the agreement. It's a classic example. Anything else? Okay. So the last category of consent jurisdiction is so-called registration jurisdiction. What is registration jurisdiction? It's one where, as a condition for doing business in a particular foreign state, you agree to be sued in that state by the very fact that you register to be sued in that state. And the question is, can these be enforced? Are they enforceable? Or is it the case that they're unconstitutional for a state to require a corporation to submit to the jurisdiction of the state just in order to have the privilege of conducting business in this state? Yeah.
Yes.
Why?
Because corporations, it's because they, instead of the service by process, it's because they exist in multiple forums or something, individuals are a separate category.
One thing that I'll point out to you in the casebook ends up by mentioning the Mallory case, which by the time the casebook was finished and bound, hadn't been decided by the court, right? The Mallory case actually is in your, I didn't assign it because I didn't realize what page it was on because the supplement didn't come out until after it was started. But the Mallory case, which I encourage all of you to read, is on page 422. of your supplement, okay? And in that case, right, the company was forced to register and submit to jurisdiction in the state as a condition for doing business in the state. And the company's argument was that since it wasn't a real contract, but it was a condition of doing business in the state, it was unconstitutional. It was unfair, right? It didn't comport with the process. And the question the court was asked to answer, and in a majority opinion written by Justice Gorsuch, the court said, no, you don't have to do business in the state. But if you know for a fact you're being asked to register to do business in the state, and one of the conditions for registration is that you submit to jurisdiction, there is nothing unconstitutional about this. Now, it is important though to distinguish between two categories of registration. The mere fact that you do business in a state doesn't mean you're subject to jurisdiction in that state. The mere fact that you register to do business in the state doesn't mean you're subject to jurisdiction in the state. What makes you subject to jurisdiction by registration is if, in the process of registering in the state, there's an explicit condition that you must submit to jurisdiction, and you abide by that condition. Is that clear? Now, this goes to the question that you were asking me, and I acted as if it was not a realistic question, but in fact it was a realistic question that you were asking, because if you read Mallory very carefully, right, Mallory is an instance in which you register to be treated like a domestic corporation. Your question was to me is that, can you ever sign a contract to submit to general jurisdiction? I said I couldn't think of one, right? But there is an example of registration by general jurisdiction, because the Mallory jurisdiction wasn't specifically based on the business you're doing in the state. The Mallory registration says, if you do business in that state, you agree to be treated as though you were incorporated in the state. You agree to be treated as though you were a citizen of the state. You essentially agree to general jurisdiction in the state. That's what the company was objecting to, because they thought it was unfair that they were subject to general jurisdiction. Yes?
What would happen if you have a case where a business has a contract, a regular person that says, oh, all claims have to be decided in Florida, but another state that company does business in has registered and submitted to personal jurisdiction?
That's a great question. It seems to me the contract itself would supersede everything. Because again, the protection is always toward the defendant. So it's up to you what you saw. Yes?
But these sorts of laws common, most states have laws.
No, I mean, it's not as if every single state has laws. Different, I can't tell you how common it is. Different states have different requirements, and sometimes these requirements are grounded in whatever history the state went through.
I just wasn't sure if it was landlocked jurisdiction where it could effectively be assumed.
No, I can't tell you to assume that every single state have that sort of thing.
Is an example of this like if you register your business in a specific state and they say you have to select a registered agent?
It's a good question. Not necessarily. That's a completely different problem. Remember when we talked about the fact that all these questions ultimately end up to this point, the notice requirement, right? To say that to do business in the state you have to agree to an agent for such a process, you're not agreeing you can subject to the jurisdiction of the state. What you're saying is that if somebody is suing you in that state, for purposes of knowing how they serve you, for purposes of knowing where they give you notice, you're agreeing that they can serve this agent. So essentially sometimes you agree to this, right? But agreeing to this doesn't mean that you're agreeing to that part of the job. Because it's possible to agree to notice and to the jurisdictional problem, but it's also possible to only agree to this. Most places have this. In other words, you know, if you're doing business in Pennsylvania, you have to appoint the Secretary of State of Pennsylvania for your agents for sale process, meaning that if I have a lawsuit against you in Pennsylvania, I have to serve you, right? Like we talked about. And I don't want to have to chase you, so all I need to do is to send the complaint to the Secretary of State of Pennsylvania, and the Secretary of State of Pennsylvania will find a way to get it to you. But for purposes of notice, I have checked my box, right? So that's good. It may or may not, depending on the law, determine that problem. Because I could still come into court as the business said, yeah, they served me, but guess what? In this particular instance, even though service is proper, they haven't shown they have minimum contact enough with the state to justify this lawsuit. Yeah.
Is that what the case was in Ratliff v. Cooper Laboratories?
But again, as I said, we're going to get to know this as the last part of this topic. But I think it's a very important question that the appointment of, you can appoint somebody in a state for purposes of being an agent for service or process. That doesn't necessarily mean you've agreed to jurisdiction. You could agree to both, but one doesn't necessarily mean the other unless it's explicitly stated in the law or the agreement itself. And by the way, sometimes your contract that you sign, it could be that the clause is not a jurisdictional clause at all. It is a notice clause that you've agreed by a contract to be served in a particular way, and for that to be enough notice, even though you haven't agreed to subject yourself to jurisdiction. Anything else? Okay. So let me introduce the case that we're supposed to talk about today that I'm going to ask you to read again for Tuesday, and I'm sure you've already covered. And it's a case that goes back to Penoria. Right? And the case is Schaefer versus Heitner. Remember back in, so far, in talking about the cases, we've always talked about all the cases since Penoria as if we're talking about one kind of jurisdiction, impersonal jurisdiction. But remember, Penoria introduced the concept that there are at least three subcategories of it. There's impersonal, in rem, and quasi-in rem. Impersonal is when I'm suing you as an individual. In rem is when I may be suing you, but I'm not suing you as an individual. The dispute is that we are determining who owns a particular piece of property. So the lawsuit is about the property itself. And then quasi-in rem, right, is about an instance in which I'm suing you, right, as an individual. I cannot get jurisdiction over you because you don't have enough contacts in the state. You're not present in the state. You're not citizen of the state. But it just so happened that you have a piece of property that is located in the state. So what I do is that I attach your property